Hi, my name is Judge now, Melissa A. Kotulski. I am the founding president and owner of International Attestations, LLC. Some of you may know me from what has now become what I've renamed my academic journal, just to make sure there's no confusion with my affiliation with the media, which I respect and honor and have actually participated in on and off throughout my life, but am more towards the academic and or sort of bench side and practicing side. So today I'm here to talk about a North American Constitution, dot, 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 question mark. This is something I've been positing for over a year now. Whether or not we might be heading towards that, it has been a question I've pondered, and also a note that I've been making to the government here in the US as well as in Mexico and Canada for their potential support of my maybe helping to lead any efforts that might come up to the Constitution arising. So I am doing this concurrent with the forthcoming forum that they have every once in a while at the University of Texas at Austin. I have also presented previously, but I'll get into that soon later. And I'm doing this hopefully that in the hopes that those that are there, because I can't be there in person at the moment, are able to participate with the text that I'm going to present and also perhaps include me in any of their conversations that they do also have coming forward. So the date is actually March 17th. Happy St. Patrick's Day, everyone. In fact, I have just had a nice breakfast with some Irish cheddar, so hopefully we move forward with that. So this cover screen shows you a couple of pictures that sort of set the groundwork for what we're working towards. Of course, the logo for the World Cup 26 as presented to my consciousness at this time, um, helps to understand where the foreground is of this presentation. The St. Louis Arch in Missouri is also, I think, a very important international icon for the United States as well as the North American continent because of its proximity to sort of joining the three nations together, but also being part of what I've done from the start with regard to establishing the business that I have, International Attestations, LLC, which has a registered trademark as well. The top picture is my husband from when I lived in the Washington, D.C. area. He had a wonderful day that day, did a nice side pocket goal. It was a very fun celebration. He was feeling a little good about it at that moment. And then on the bottom are my basketball trophies as well as my dog's trophies for the good work that he's done for his own competition. I have no children, long storied history. Some of you may know it. But so my investment in my dog is like having one of my own champions hopefully get presented to the table, even if I can't get train my own Olympians of my own biological line. Perhaps I might do so in other ways when I serve as an arbitrator at the Court of Arbitration for Sports. So the sources of this come together in a lot of varied ways. As many of you know, I'm very learned when it comes to resources, not just official resources. I also take a look at things like Legally Blonde and other kind of resources out there which have their own official status, as we have just sort of skated away from the wicked year of the Academy Awards. But also, I have scores of engagements in commercial and government venues at the local, state, federal, and international levels, from Pacific Grove, California, to Wethersfield, Connecticut, to Cali, Colombia, to Morocco, to places all over the nation and the world, where I've been able to engage with those various venues, and also um, sometimes contribute to their reporting mechanisms and things of that nature. I've done research in archives all over the world, both in person and remotely. I have looked at many around the US at all levels. I probably just about oh no, yes, every circuit court has had my eyes upon their archives, at least remotely, and then throughout Europe, particularly in English language archives, but also in Spanish and French, in Italian and some German and a little bit with Russian now too. Um, I've also done it with South America, particularly in Spanish, and then of course North Africa and really the rest of Africa remotely too, with my engagement with the African Union and other international organizations around the world. I have also done years of academic journaling officially and unofficially, as well as on my own, as along with other people in collaboration with others. Going back to the 1980s when I was thinking of the sun gods writing that I wrote from about Egypt, the Egyptians way back when. And then, of course, I've read every single constitution that I can get my hands on in English, Italian, French, Spanish, a little bit of German, a little bit of Russian. And so I understand that not just the structure, but the substance of all the constitutions that are out there. Some that are written in other languages that are translated to English as well, too, or all of those as well. Um, whether it be Iran, the UAE, or any of those other nations that have been translated from Arabic and Chinese and things like that. I also wanted to say I'm really grateful for all the peoples that I've interacted with, from the folks that, hang out outside of coffee shops with a cigarette to those that I've encountered that are judges and justices of Supreme Courts and international courts around the world. So I am grateful for every encounter that I've had and very happy to bring that knowledge to a North American question of a constitution because of that encountering of all peoples and places and things that I have throughout the nation. So we're talking about three nations in the North American question, although recently, just as I was finishing up with this presentation, there is a question of an acquisition in the North Atlantic of a major set of property that's associated with Denmark, especially. So it should be interesting to see how that goes forward with the question and what that will do with this set of flags here. But for the sake of this, for this purpose, we have currently the three nations that are sort of the principal contiguous nations in North America that will be hosting the World Cup 2026. That World Cup 2026 could lead to a constitutional question, and I've been positing that for about a year now, and I'm hoping to compile a group of peoples so that we can have a convention to yay or nay it, and then bring it to the appropriate votes that it might need to be for the populace to understand. Um, so that is sort of the long and short of this presentation, but it's focusing primarily on the participation of the people, of the public, and whatever the public may be embodied, whether it's an individual public person or a corporate public person or something of that nature, how they may possibly engage, and then how the government may engage with them as they work towards such participation, and what sort of legal tenets that are already out there that we can look to as we develop such. So the ABCs of North American participation. I am going to review what has gotten me to this point, the things that I've done to this day, and March 17th, 2025, just about a year before we start really hosting some foreign folks or international folks from all over the world with probably lots of big bucks that can probably help enrich what we have as a nation and maybe even really substantially change it in the United States as well as in Canada and Mexico. So we'll be going over seven different sort of tendrils of my analysis of this particular question. I'll also look a little bit to how public participation can be contextualized with what I know with the very resources and texts that I've studied as well as my own personal experiences. And then I'll make three principal suggestions that sort of embody each of the particular branches that could arise, for a supranational governing structure that could happen or form as a result of the development of a North American Constitution. So World Cup 26 was conceived, and that's what I'm going to look at first. And it's January 24, then look at August 1st, 24, when I did with World Constitution Day with Jim Scherer, who hosts it and is a fantastic host. He helped to sort of get that to the world, and I have a little synopsis of that presentation. And then, of course, I'm looking at like federal concerns, international law, commerce and industry, culture and arts, and sports diplomacy, as well as sports arbitration. Um, and so that will be presented through the next couple of slides in terms of how we get up to the question of participation at this moment, which is really the fourth of a series. Um, so sitting in my room with my newly acquired desk that could move up and down so I could stand or sit with it. It was a beautiful desk, and sweet crispy. They're really very cost efficient and oh my gosh, amazing. In any event, had also this map on my desk, and I wondered, well, how can I get this? What's going on with this map? And I was concerned about the authenticity and the integrity of its structure. And then I looked up the fact that the World Cup was coming, and I said, oh, World Cup maps. Wait a minute, supranational governance, Europe. Oh, wow, this could happen with the US, Mexico, and Canada. So, and all of that sort of came together with that moment as I was sitting in January 24, sort of thinking of that, my Google moment, so to speak, as they came up. If you know the Google, it's the Google D. The word came up from a baby when a mathematician was trying to figure out what to name the number. So then I did my research, continued analyzing it, worked through a lot of sort of questions, and went through a lot of other things on the sidelines, and then was able to present the World Cup 26 question, a constitutional question publicly with a presentation at the World Constitution Day hosted by Jim Scherer, August 1st, 24. So there are 16 cities that will be out there. Canada has two, and Mexico has three, while the U.S. has the rest, the other 11. So you can see the names of the cities here: Toronto, Vancouver, Guadalajara, Atlanta, Philadelphia, et cetera, et cetera. So each of these cities will end up having the great foreign powers and international factions with probably some good pocketbooks, scooping up some good property around the area as they're around there. So it'll be wonderful to see what's going to happen as we present our American voice to them as they come to visit. The typical constitutional provisions were reviewed in that presentation, like what usually happens with constitutions. You have the type of government, who's it comes into being, what kind of language you have, the legislature, executive, judiciary, and then with the European Union and the African Union and things like that, you see a super regional approach. So how does that work? And the OAS helps to give some prescription to that. The Organization of, excuse me, the American Court and things of that nature help to give sort of an analysis of that. So these are some of the potential provisions to consider as we move forward. And I brought that to the presentation. Then I looked at what are the sort of distinctive tones of the constitutions of Mexico, Canada, and the US that I think we need to really tease out as we consider a constitutional question, with Canada's being so intimately linked to the Magna Carta origins of the UK, as well as the Commonwealth and things of that nature. And then Mexico being so verbose and copious with their presentation of their constitution in a manner that shows all of the sort of tenets and tendrils of change, so that it's very publicly consumed so that people can be aware of it. And then the US, we are purportedly the oldest, although I have a suspicion that there may have been more revisions that are presented to the modern eye, but that's another story. So, and plus, we've had at least a little under 30 times where we've had constitutional amendments. And since the this presentation, I posited whether the U.S. might want to practice with a constitutional amendment by extending the tenure and time that we can have our presidents sit atop our executive branch. We currently have a two-term, 4-year each term sort of amendment that makes sure that they don't go any longer than that time, coming from the time that after FDR had served for so long, and some people were a little concerned at having perhaps a dictatorship arise. And since that time, I've posited maybe that may be where the U.S. can practice an amendment procedure ahead of maybe what would be part of that process that could be for part of the implementation of a supranational governing document. Um, and so I would argue for an extension of it because it is very tenuous to go through the election process for the U.S. It's very I think it's very, very tough. And I don't think it's so I thought that'd be a good question for Congress and other folks to start to really ponder whether we might want to extend the tenure for it's a good question to start with. But there are other things that people could think about in terms of how we can form the populace or get them really together, even if they're discordant on occasion, to be prepared for that kind of moment where we can be really good hosts and hospitable to what's going to be coming, as well as make sure we protect our interests. So the other thing that I looked to were, or I presented were some of the questions of other sovereignties that we can look to for comparison or by comparison. I looked at the previous USSR, the US, Russia has gone through. And I'm arguing that there might be a third one afoot, but I'm starting to think that there might be a third one afoot. But Russia has gone through so many different governments in the last century or so that I think they're a good place to look in terms of how to consider a constitutional question, but also a regional, right? Because they had the satellites under USSR, the European Union, the African Union, ASEAN, our sub-states. I also looked in the US at a couple of states to sort of figure out how to really develop the constitutional question. Tennessee and Virginia were particularly fun to look to because of their borderlands and how their constitutions really even acknowledge what happens with the borders. And then Texas also made me consider how that Texas Constitution has evolved throughout its history, it really sort of waxing and waning to the sort of engagement with what's happening with Mexico. And I think it's very instructive to figure out that kind of engagement with the nation if we are to negotiate diplomatic exchange sufficient enough to lead toward a constitutional question, if not an actual constitution. I also considered some of the benefits and issues and suggestions for a North American Constitution during that first presentation in August. Thought about, sort of getting all sorts of parties to the table, but also thinking, well, if there is going to be armed conflict, that we are prepared and perhaps we might be able to do it preemptively rather than have more loss and casualty by sort of getting people together and consider the question. The second tenet or the second part of this is the issues that could come from it. There's, the idea of a pan-continental engagement, but also a divisiveness that could arise. Some people might go, where there's more nations, there might be more breaks, like, what happened with Kosovo and other nations in Europe. Although there's the European Union, there's a lot of sort of breaking down too that's happened concurrently. So you have to sort of balance that out, right? And then the alliances that could arise beyond just geography is also a question. Well, while we have the UK, Mexico, and Canada, they're contiguous states. They, in fact, each have their own sets of alliances and organizations with which they're connected, especially with, for example, Canada and the Commonwealth, and perhaps Mexico with its sort of at least linguistic alliance with Spain, amongst others. And then, we have our own sets of copious bilateral and multilateral agreements that we have to work towards and figure out how will that look. And then my suggestion is to be careful with adding, my last suggestion for that presentation was to be cautious about adding another layer of governance, how to sort of distance that from the people and those that have an interest in maintaining good governance with their local, state, federal levels, and what will that mean for the regional level. And then, thinking about, well, ways that we can make sure that we do public and private partnerships as we lead up to it because of the sponsorships and things that come with a World Cup, for example, but also what that could mean for support of the Constitutional Convention itself. And I think Richard Albert, who is the organizer for the forum that is in Texas, as I mentioned earlier, the Constitutional Forum that they have periodically at Austin, at the law school there, he often shows a really good example of how to bring public and private sponsorships and partnerships together through the presentation of who he gives credit to for supporting his efforts. And then the other part is sort of the natural document of the true peoples and their 21st century lawmakers. So, like, this is actually a really good tenet of that presentation. It's a nice little sort of focusing on it that this presentation is an interesting tenet of the August 1st presentation because the fact that there's a sense of public participation, which again has evolved since that time, and then government, business, and other efforts that can be leading up to it. So that was my sort of long and short of it. So the other element of my analysis has come from continued efforts to serve as an arbitrator at the Court of Arbitration for Sports and what that means for as a multi-generational American with international affiliations around the world, what that could mean for preparations leading up to World Cup 26 and perhaps a constitutional question. Many judges throughout history have straddled both their national efforts as well as the international efforts without having to be called home, which is a little bit of a question of what is happening with what has recently happened with the ICJ president, who resigned substantially earlier, his tenure substantially earlier, not just as president, but as a judge on the International Court of Justice, leading now to the Japanese judge taking over after their deliberation processes. That kind of question is an interesting one to think about because he, having gone home rather than sort of straddle both worlds because his home really needed it, I think it's something we might want to ponder a little bit as we have people at the international level negotiating there and making sure that they maintain both their home interests as well as their interest in what's happening in the international world without being called home. But apparently Lebanon needed it. So in any event, sports diplomacy and arbitration are very much part of this. And what you see here is my engagement with my with Richmond in Virginia. I've been part of every tendril of sport throughout my life. Baseball was a principal, was sort of my entree into the sporting world. And my cousin, he did a pretty good job in getting through. He's a successful professional and family man in his own right. But he showed me some of the ins and outs of what happens with at the nearly professional level. But I've also engaged in it on my own throughout my life. And so every kind of sports from basketball, baseball, lacrosse, and so on and so forth. And obviously, the three principal sports of our nations, or the three nations, seem to be for Mexico was soccer, for the US baseball, and obviously many others, but these are the sort of the pastimes that we talk about. And then Canada, I've been told, is twofold now, both lacrosse and hockey. I'm not sure about the lacrosse tenant. I haven't found enough written documentation of that yet, but I definitely have know about the hockey. So these are things that I think where we as a country and as a continent need to prepare for in terms of how to protect our interests in international organizations with our those that do the practice, that do the analysis, while also protecting the interests in our national worlds as well, which is always a longstanding question, especially with some of the judges at the and legal scholars at the United Nations who have always said, "Oh, you're doing too much with your own national interests," and "Oh, you're supposed to distance yourself." But I think part of that sort of ongoing question that goes back to Judge Koretsky, for example, while he was at the International Law Commission at the very first sort of tumultuous meeting of that commission, where he's very disappointed that people were too adherent to their national standards and not thinking about space and the sky and beyond just national borders. So, this since that time, I developed a sports arbitration page or a sports diplomacy page, and you can take a look at that if you'd like. This is just a screenshot of it, so just to show you some of the analyses that I've been doing. And these are all the different sports that are at the Olympics, and so just to get a sense of, what we might be preparing for 28. With a constitutional question, as we at the U.S. in particular in the North American continent, we'll be preparing to host not just the soccer world, but also all other worlds when it comes to such. So, and I think we have a great president, whether you're right or left on the spectrum, or Republican or Democrat or anywhere in between. In the United States, I think for the U.S. efforts, it's probably a good idea to have someone with such a intense background with entertainment at the helm and with the bird's eye view as what's going to happen for the years to come with these two big sporting events happening. So we also have territorial. Sorry, the next tendril of my World Cup 26 preparation comes from federal concerns. I was looking at territorial integrity and diversity jurisdiction as I was in Blaine, Washington, in fact, and thinking about, in the British voice or the British accent that I had presented to me with my civil procedure professor, you know, territorial integrity, no, not territorial, diversity, complete diversity on either side of the V is how I have a sort of, I think of it on occasion. And because it's with a British accent, it brought me to that sort of Magna Carta moment of 2015 that we were working towards. And my concerns within the US, and I have not done substantial research for Mexico and Canada enough to make an affirmative statement for their interests. But I'd be happy to hear what my Canadian and Mexican scholars with international perspectives might be thinking about with that, with the diversity jurisdiction in the United States, the diversity jurisdiction uh, overall, at least more recently, presented to the legal consciousness as they try to figure out how to get cases and controversies to U.S. courts. The concept of diversity jurisdiction is to ensure that there's enough of a reason to bring it to a federal court as opposed to a state or a local court. So, is there enough diversity? Diversity being, are they from two different states? Do they have enough substantial context in one state versus the other? Diversity jurisdiction questions are the ones to sort of think about in terms of how we get actual Americans with their level of funding to federal courts in and of itself is a struggle. Can't imagine what will happen at the regional level, especially as we've been preparing for this World Cup moment. And then the other element of it, sort of a corollary, was the territorial integrity question, which again, putting those together made me think about how do we respect that as Americans try to negotiate their own systems? North Americans try to negotiate their own systems. And territorial integrity is a large tenet in international law, especially arising from, or most modernly arising from the charter's provisions indicating that territorial integrity was an important tenet of protection of the interests of the nation states that are members, as well as others that are members of the United Nations, to ensure that while they engage in international affairs, that they also have the ability to protect the interests of their nations. So that's a question that I put out there, and if there's anyone that would like to participate in the page that I've developed for it, I'm happy to hear or keep, even if you've written something separately, I'm happy to place it on the page so that we can get this question going further. What does it mean to protect the territorial integrity when we have issues with those that access the federal court systems because of this sort of barrier of entrance? The other element is the questions of access. Again, that sort of goes to the other element. And then the final is this sort of the legal publications that are being consumed and dispersed by briefing attorneys that form the opinions of judges. I recently went through a set of legal documents, and usually when I do my research, I go all the way to the beginning of the US, especially when it's in the federal world. Of course, I try to contextualize even deeper with UK and other influences. But and I review everything, and I realized recently that a lot of that early stuff that's presented in the technological devices that we have at our disposal may well actually have been modified or be disingenuous or just not authentic. So I got concerned about that, and I presented that at a recent case in the First Circuit. So that's one thing that I'm sort of wondering about as well. Um, the other element is the international part of it, right? Of course, World Cup 26 in and of itself is international, and North American, even if it's only three nations, would be a trilateral effort. But I'm concerned about, our Magna Carta moments that were leading up to the World Cup 26. Myself, I've had my own engagements that have, I think, in part been put out there, with two personal cases that went through. To a certain level, and sort of with concern that maybe some Americans were not able to negotiate tenure in various uh, places, whether it's in the academy or in the court system, because of the sort of strategic elements sort of rising. We're very open to considering other nations and their developments, but also sort of wondering whether some of that openness may be sort of making it difficult for our access to these leadership positions. Um, and also perhaps thinking of it not just in the context of the UK, but Magna Carta influences the Commonwealth and all other constitutional formations, in a large part in the Western world, especially, but or what is has sometimes been called the Western world, especially. But and then of course we just had an election year, new president in Mexico, Trudeau, and then Trump for North America, but then all sorts of stuff going on all over the rest of the world. India had I guess it was a real sort of up difference in the UK. So a lot of different changes leading up to this World Cup, especially. And then at the International Court of Justice itself, the Russian judge who's had tenure at the that governing body for since the 1940s, since its inception, they've always had a seat. Seem to seemingly pass the baton, or maybe the spectrum shifted a little bit with the influence of that part of the world to Romania, uh, rather than or retaining their position. And so that's another thing to think about. And then our current judge, Cleveland, wondering whether that kind of shift, because before him was the UK, which also had tenure for since the inception of the court. Those are my five perms. Some of you have heard of my research about the five permanent nations on the UN Security Council, and except for China, the other four have pretty much have had tenure there their entire time, or the entire time the court's been in existence. Whereas China actually did have a small period of time from the 60s to the 80s, I believe, where they didn't have a judge on the court. So although Judge Gevorgian may have left the International Court of Justice, there's a possibility that there will be a gateway back or a pathway back, much in the manner that the Chinese judges have have reclaimed their position. But it could just be that it's a shift in the geopolitical situation, and Romania is indicative of that because they now have a very ably minded and very much influenced not just from the East, from the European world, but also from the Russian and Central Asian world that sort of is around Romania, sort of bringing that voice to the court. And he ably showed that with questions that he presented during the climate change proceedings, especially. So I wonder what that will happen. What will that mean for the U.S. as we go forward as well? Um, we also have concerns, I think, about commerce and industry for the U.S. as someone who's established a small business and has seen what that means. I come from a tradition of small businesses as well as big businesses. My grandmother worked for a very large hospital, but my grandfather owned a small business. So it's a nice sort of understanding of that. While my mom was corporate and my dad was union. So it's kind of like interesting to sort of watch that growing up, but then to sort of have my own now experience owning my own business. So a couple of times supporting others along the way and their small businesses, but also straddling every type of business in the world, or, whether it's a small business to, tens of millions of people. I've been able to sort of understand that engagement. And this is the list of corporate sponsors currently for the World Cup 26. And so most of them predominantly have a huge American nexus, US nexus especially, but there are a couple of others up there as well. Now there's one, it's I don't know how to do the pointer here with this thing. So this right here, where is it? Right here. I'm not sure exactly what it was. I couldn't quite get to an efficient or an effective translation of what it is. So if you know what it is, go ahead, feel free to email me and tell me what they are exactly. We're gonna have a barking probably buddies with me right now. So, in any event, so these are the corporations that are involved with the sponsorship of the North American, excuse me, the North American World Cup, and I think that corporate involvement will be imperative for understanding how we move forward with a constitutional question, if at all. So then. And that picture of me is of one of my own corporate sponsorship, a very good blood orange juice out of Florida, bringing an Italian flavor to the American palate through their development of that brand, especially Kennesaw juice. They're very, very good. So that's why I was just sort of putting that picture up there for that purpose. I also looked at the culture and arts that surround the constitutional question. You know, we want to make sure that we include as many factions of the population. I talked about scientists and businesses and other things like that for the first presentation. But also, you know, we have beauty queens doing good things. I met a Connecticut's Miss Connecticut at an event last year. She was proudly wearing her crown. And then I also um, thought it was important to look to making a song. I actually developed my own. I'll talk about that in a second. I also considered the lineage of words, especially in the 90s, and not some of these three words seem a little tough, and they're in the three languages, three principal languages of the three nations of the North American continent. There's fetard, vagabundo, and spaz. These three words were, I think, very popular during a certain time, not necessarily in the central consciousness of communities, but definitely part of the linguistic turns, so to speak, of perhaps more social environments. And they are definitely, I think, one thing to sort of think about, well, as we develop language and move forward, what are we going to do with these kind of sort of imageries as we have these three nations, perhaps from the European motherland, so to speak, being sort of categorized in these certain ways. Fatard means it's sort of like a party animal. Vagabunda means someone without a homestead or a central property. It's who kind of moves about. And then spaz is sort of a sort of a kind of a someone that may be a little bit socially inept and maybe disabled or something like that is sort of part of those three sort of less than sort of nice words to say, not necessarily. But why these are the three languages that we have coming from other worlds. So I wonder if perhaps we might think about ways to sort of structure language in the next stage to ensure that we empower folks a little bit more. And then my s'il vous plaît goes back to the linguistic involvement. I have a long-standing heritage as a linguist myself. I have multiple languages under my belt. And someone asked me which language I have, and I told them all because I have encountered all of them and studied all of them in some capacity. I'm nearly 50 years old, so it's a long-standing study from a very early age, being born into a bilingual household. So the reason I put s'il vous plaît is because I was analyzing as I was actually driving through Nevada, thinking, well, you know, we struggle with getting to the linguistic stage for our American voices and those that do become linguists. And I had an encounter with a Navy admiral who said that he too did, and he was much like me in terms of visage and European background and in the U.S. And he said that his folks also struggled with that sort of linguistic acquisition as well as encounters and involvement at the world stage. So s'il vous plaît is my sort of appeal to the international community to ensure that we include our American linguists there. And then I wrote a song about 15 bulgogi, 15 judges in the region of China. So that's something that's still coming out. But then I did this one on the picture on the top right. I guess you can't see it from here. I guess you can't. But anyway, the picture on the top left, rather, is of me and my niece and nephew at John Jay's homestead. And it was a great moment for us, and it led me to writing a song. We played football at John Jay's homestead, and he jumped branches like you jump families. We played football at John Jay's homestead, and it was raining like it was that time. So I thought it was fun to put that out there because of the sort of football in the world stage, generally soccer and football in the US especially is a little different. There's a lot of padding involved and a lineup, and it's very organized and structured in terms of getting back to the lineup, whereas soccer is sort of ongoing from the start of the match to the end of the match, right? So that was sort of my way of sort of put something out there about football, but also thinking about, well, what's that going to mean for the American football movement as well? Maybe they should be supporting this particular World Cup moment. And maybe it might be fun to have some overlaps between the two, of course, acknowledging the differences between the sports. And some of that did kind of arise, I think, with some of the commercials during the Super Bowl this year, especially. The Drew Barrymore one is actually a one that comes to mind most prominently. So, here we are after all that to the sort of nuts and bolts of what this presentation is about after we've gone through this sort of context. Public participation. What exactly is public participation and what does it mean for a possible trinational regional constitutional effort that would hopefully maintain the interests of each of the three nations that are currently there, but also ensure some sort of international engagement that's an alliance of sorts in a geopolitical or a geographical manner, especially with these three particular nations. So um, public participation could be, like was referencing earlier, individualized. It could be also corporate, and it could also mean that it's outside the realms of governing structure as well. But it also could be very much intimately linked with governing structures. I also will look at examples of international law, and then talk about some of the knowledge pooling and satisfaction, and then some cautions. To think about when we have public participation. So uh, I have a quick little review here. I sort of touched upon some of the public participation definitions. And, who is the public? Refugees and stateless should probably be included in some fashion, especially even those that are no longer tracing about in the North American continent that may well have intimate links to it. Perhaps we can call back Brad Pitt from 7 Years of Tibet or whatever that is. In any event, we also have implants and other immigrants to North America, exiles and other immigrants from North America, and then international community itself that has an interest and invested in our nation, in the North American nations. And then, of course, all the different generations of peoples that live here and what that means with sort of the overlap and, who they come from and what they become and, how they influence their cultures. I got a little concerned and it was a little, I guess, a little bit of a cloud over my head about muscle and muzzle with regard to property. And so I thought also it'd be something to think about and then move on from there. I also put in the word populist to think about public participation, and think about some of the examples in international law that have arisen more recently and that have included more public voice at the international stage. Uh, um, for example, NAFTA leading up to USMCA. NAFTA did not include any sort of articles or provisions that really gave a gateway for public participation. Although it does have a dispute mechanism or did have a dispute mechanism in place that allowed for those that were corporations that were doing business across boundaries between the three nations of the North American continent, the three principal nations, Canada, the US, and Mexico. They did not really expressly provide a pathway for those that were in the public to give voice, to participate, to help influence, um, besides that dispute mechanism, resolution mechanism of those that were already engaging at the North American stage through their corporate involvement. The USMCA was a nice turn of events for that tenet, like it or not. Some people may not be as open to public participation because diplomacy is sometimes very, very delicate with what needs to happen between folks. But in any event, the USMCA does include it, and that's US, Mexico, Canada, sort of the sort of the Trump administration put into play almost immediately upon their previous time as president, with him as president. And the USMCA includes especially moments where the public participation can arise through input systems, especially. where they allow for example, especially in the environmental realm, people to submit comments about certain environmental questions that go and influence all three nations. So that's a relatively new development that many of the articles throughout the USMCA also or include or excuse me, and many of the sections throughout the SMCA include articles and provisions that allow for some sort of public participation that's not just that corporation where it can have a dispute mechanism or dispute resolution, but and this in part comes from the other FTAs that are there. That was one of the distinguishable factors of the NAFTA itself, where from as compared to the other FTAs, there was more involvement and participation allowed by the public. And NAFTA was a very politically charged moment. The companies and the peoples and the unions in the U.S. were very averse. Some were very averse to its implementation. Uh, but the USMCA was sort of an offshoot of that. And this is again a trade-based, a trade-based set of treaties though to focus on. So it's a subject matter set of treaties to focus on, but not necessarily an all-inclusive governing structure set of treaties, but something to look to as one considers public participation. Many of those tenets that did arise in the free trade agreements movement, I think is really instructive for understanding how to include public participation in the development of the North American Constitution, if it arises, and or the implementation of the tenets that do get formed within the Constitution itself. Um, Development meaning for the first tenet is like those how they're involved, how the people, how the population and populace is involved with it. Amendment procedures, for example. Inputs at the United Nations. That's also a place where people can come and provide their feedback, not just in the human rights realm is very verbose. There's a lot of folks that in the various human rights factions publish a call for an input, and an input is basically you get to make a note about what you're concerned about with whatever international policy or law is forming, and that in itself can help instruct and form things like customary international law, but even maybe even the actual jurisprudence itself in some ways. The other way to sort of make inputs at the United Nations is through the General Assembly, especially they do have oftentimes with the resolutions as well as the various activity at the General Assembly include, sort of open panel or open floor for lots of parties to be involved. Usually it's, the international organizations, but they also have oftentimes a section where they allow the public to participate as well. So that's where if you're thinking about ways to develop, this is another voice to think of and look to. Um, so that is that in terms of that. So the knowledge pooling and satisfaction, I guess we have a little bit of a blank slide there, but basically looking to making sure that we participate, allow the people the voice to participate, much in well, I'll get to that part later, but giving that voice is, I think, imperative. But also the satisfaction of at least having a voice, and seeing it come into play. Now, that I think is important in terms of developing a sub-regional or a super-regional governing structure in and of itself. We have also Chile and mob violence as my two cautions when considering public participation. Chile just recently had a moment where they were not able to finalize the constitution that they had put all this effort into developing with a referendum. It basically struck it down. Now, I don't think that it's since been um, carried forth, but it was definitely an instruction in terms of perhaps maybe having external parties having too much of a voice in the development of a territory of a national constitution. So something we had to think about, especially as we have international factions with big pockets coming around all three nations. And then to be concerned about what might get riled up. People get upset. They get, there could be mob violence, and I think it's important to be cautious with ensuring that those that are participating or that are getting into the know of some of the questions, allowing for the discourse to continue and get to the right place before it becomes a question to them, might be a good way to sort of forestall some of that, but also ensuring that they have access to it if they can. So the three principal suggestions that I make really relate to um, you know, the rulemaking process, the judicial body examples, and then a suggestion for what the three nations could do in terms of preparation. So the first is the principal suggestions of the rulemaking process. So I think it's important to get the public involved in the rulemaking process. It's one of the things that we do in the United States, and I have not found something synonymous in Canada and Mexico, but what does come to mind for Canada is uh, the mechanisms that they put into place to deal with the Native American population sort of healing process. There was a lot of public participation where there was outreach efforts for them to help develop the rulemaking process that happened as a result of that. That was what's come to my consciousness, but there could be other rulemaking processes in Canada and Mexico. But as in the US, we have regulations.gov, especially although some agencies don't exactly always use regulations.gov. And I actually have encouraged, for example, the United States Supreme Court to implement such a mechanism for their rulemaking process. But basically what it is the rules that develop or help to instruct what the sort of procedural processes and mechanisms that arise in various agencies, and the executive, judiciary, and even, well, kind of Congress a little bit. Yeah, they do open up too. So all three branches in the United States go through this portal called regulations.gov. They usually post a proposed comment or proposed rule, and then the public has an opportunity to comment on it. And oftentimes they just listen, but sometimes they actually implement what is stated by the public to maybe in that round, but perhaps maybe not in that round of rulemaking changes, but perhaps in the future. So sometimes it takes a while for the rules to really be implemented in terms of the change or for the public to get the voice in the rulemaking, but at least they have the ability to participate in that process with things like that. And so that's something that may well manifest itself for the rulemaking process at the supranational level like they have at the European Union. The European Union principally comes from elected officials or selected officials that come from the different sovereign nations at the supranational level. But there is a small conduit where they can have some participation through the voice of the people or the individuals that have concerns about what they're developing. But I don't think as much as what would happen now, especially the post FTA movement with NAFTA, if we were to develop a new governing structure document that would allow for a conduit and a gateway for the public voice to influence what the structure would happens. Um, that brings me to the dispute settlement processes that they have at the that we could probably develop. And one of the dispute mechanism processes is looking towards how we might develop an actual judicial body for the three. Now, NAFTA had a settlement mechanism in place that was verbose, not oft used, but enough for the 20 plus years that 20 or so years that 20 plus years that it was in place. And it's definitely, I think it would be our sort of UK court system that influenced the US at the beginning of its inception, leading up to our court systems in the 1700s. If we consider the NAFTA dispute mechanisms, although a little more like those that were the courts here in the US or on the continent, leading up to the establishment of the Constitution, more so that than anything else. So it'd be kind of nice to have that body of law to help instruct the current any judges that might sit on those bodies to develop their own jurisprudence as applied to the three if there are disputes that arise. Another place to look is not in the North American world, but at the Court of Justice and the European Court. The European Court and the Court of Justice, they so one court deals with sort of national disputes, usually are just sort of the governments that can have access to it, but another does deal with disputes that arise across borders within the European Union, automobile accidents, intellectual property, even just property, and then nationality and things of that nature. What does that mean in the context of regional government? And they have a lot of interesting jurisprudence centered on these particular topics, but they're not. It's not all inclusive. This is not an exclusio. That's definitely something to sort of ponder as we move forward to settlement of disputes if it does arise. And I think it'd be a great way so we don't have to keep having the Bivens claim and everything else about cross-border shots, although they're very instructive. And one of the most recent cases that the U.S. Supreme Court did talk about, on the one end with Canada, the smuggling case. And on the other end with Mexico, a agent shooting across the border case. Those two are cases that were presented to the U.S. Supreme Court. But again, if they had a supranational place to do so with a North American issue, those two cases may result in, once that sort of exhaustion arises at the U.S. Supreme Court or the Mexican and Canadian Supreme Courts, it's very possible that they might arise to that regional level as well. It's an interesting note about the Canadian Supreme Court. It's its own body, and it actually is older than the UK Supreme Court, which is interesting because the UK Supreme Court, or excuse me, the Supreme Court that's out of England, excuse me, that English Supreme Court is relatively novel, and we actually hosted their Chief Justice relatively recently with our current Chief Justice as we were leading up to the Magna Carta moment and had discussions about Magna Carta with her and things of that nature. So it is just a sort of interesting side note. So perhaps having that in our minds as we present forward with how Canada can negotiate its own international involvement while developing this potential for a constitutive document between and amongst the three nations that are part of its region. So that's a bit of an aside, but the final thing is, in terms of suggestions that I have, is this the census. Now, I think, for me at least, it's a little late in the game, March of 2025. Usually, all that preparation leads up to hiring and whatever in April, and so that May can people can go out during the summer and really just do what they need to do, at least on the streets. And then, there might be some technological census taking, so to speak, as well. But I suggested that we do a tri-national census where we have a collaborative effort. And this was going back in early November, though I started some outreach effort in October about it. I posited maybe what it might look like and maybe some of the funding that might go into it and, how much it might cost and how we can get things together and, employ people across borders and really just work with each other in the three governments to figure out who's here, and what property do they have, and maybe even, I know it's a hard question to ask in the U.S. context because of the U.S. Jurisprudence around census formation, but how long have their families been here? How deep of a heritage do they have with the nations? These are things I think that are important to help protect the interests, not only for the Constitution, but in the off chance that we may all be conquered. I mean, nobody really wants to say, oh my God, the US and Canada and Mexico are going to be conquered, but there's an off chance that could happen. Maybe it's already happening, who knows? But in any event, I think even the conquerors, so to speak, if that does arise, would have an interest in having this arise with the people that develop it because it helps with the sort of post-conflict report making, as well as sort of the interest they have in managing the new country, if that ever happens. I hope probably never, but everybody. That's my argument, is that both international investors that want to keep the U.S. going and international investors that don't, perhaps the U.S., Mexico, and Canada, maybe they would be see the benefit of making sure that that record keeping goes forward with regard to legitimacy in the world stage if something does arise with that. But of course, the other part of it is just to make sure that we know who we are as we go forward and develop a possibility for a North American Constitution with the peoples that are already here, and the places and the corporations and things like that, but also inviting new ones too. To the right degree, and figuring out what that looks like. So I put that out there to the three census bureaus, and I put on my little outfit here to say, I'm at the ready to help, if needed, for any of the management of it if that does arise. And so that's the long and short of it. Me climbing a mountain on the left, and on the right is the Olympics '96, with a couple of gold medalists during that time, at a beautiful restaurant in Atlanta. It's a rotating restaurant. It's very nice. And so these are the things that we're working towards, trying to figure out what will participation look like by the public. And these are the three things to think about. The public could be participating in a census, although it's late in the game. It could still possibly. I've done, I've brought together other things in a shorter period of time in my life for sure. So if ever that does happen, I can get it done for all three of us if needed. But in any event, it is a little late in the game for a census, but it's possible that it might still arise. Of course, a judicial body, what will it look like in certain terms of the tenets and the articles that are formed in the Constitution, is something to consider. And wondering how the rulemaking process will include the voice of the people, and how they'll elect their representatives, is something that I didn't totally touch upon above, but also in terms of including their thoughts and ideas into the rule making process in a public way, so that they one can have attribution for it, but also sort of have the satisfaction of being involved. So we'll see. Goal 2026 is still upon us. We're still working towards what we need to do to get there. And I hope that all of our ducks are getting in a row in the US, as well as in Canada and Mexico, and that we have a really great time in the process of getting there to the World Cup, but also maybe even see how we might be able to develop a constitutive document, if at all, between and amongst the three nations, principal nations on the continent. And with the Gulf of America change of names, it might well be in process.